Tomorrow, we will see something none of us has ever seen before: the criminal prosecution of a former American president. For the first time, Donald Trump will face a jury of his peers in a case that could carry prison time. Trump's hush money and election interference trial could be the ultimate test of the rule of law and the nature of accountability in this country. In less than 24 hours, the prosecution and the defense will deliver opening statements in front of 12 members of the jury and 6 alternates, laying out the evidence for and against Trump's guilt. That's in spite of multiple last-ditch efforts by Trump's team to delay the start of this trial. As a reminder, Trump is charged with 34 felony counts of falsifying records. The Manhattan District Attorney accuses Trump of interfering in the 2016 election by disguising payments to adult film star Stormy Daniels to keep quiet her allegation of a past sexual encounter with Trump as legal expenses. Trump has pleaded not guilty and denies any wrongdoing. He says he'll testify in his own defense, and tomorrow, Judge Merchan will decide how he can be cross-examined if he does take the stand. During jury selection last week, an angry and defiant Donald Trump tried making his case to the only cameras allowed outside the courtroom. Here's a taste of his many hallway press conferences.
It's a case that should have never been brought. It's an assault on America. Legal expense. It's called legal expense. That's what you're supposed to call it. But all of these are stories from legal experts saying how this is not a case. The case is ridiculous. There's another one. The case is ridiculous. The judge has to take off this gag order. It's very, very unfair that my constitutional rights have been taken away.
Prosecutors say Trump has already violated his gag order at least 10 times, including sharing a comment on social media calling jurors, quote, undercover liberal activists. Judge Merchan will weigh in on the gag order Tuesday and could fine Trump for those posts. And that's not the only threat to Trump's finances this week. At a hearing also tomorrow, the New York Attorney General will seek to cancel Trump's $175 million bond in his civil fraud case after questioning whether the company that issued the bond has the money to cover it. If the judge agrees, Trump will have just 7 days to secure a different loan or have some of his assets seized. But looming over all these cases is the Supreme Court, which will finally hear on Thursday oral arguments in Trump's claim of presidential immunity. The question at issue here is a fundamental one. How much can a current or former president get away with that the rest of us can't? Make no mistake, if the high court rules in his favor, it could derail all legal efforts to hold Trump accountable for his actions, alter the rule of law, and change the nature of American democracy. Trump has clearly been a little obsessed about all this, posting online about presidential immunity more than a dozen times this weekend alone. Trump will be stuck in New York during his Supreme Court date, but expect his legal team to bring the crazy even without him. As you may remember, Trump's attorney told a lower court a president can be immune from prosecution even for ordering a murder.
Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes.
Just let that sink in. An argument that would let a president or a former president get away with murder. And if that's an example of what we could hear this week, buckle up. Joining me now, former federal prosecutor Glenn Kirschner. He is an MSNBC legal analyst and host of the Justice Matters podcast. Also with me, Mark Joseph Stern, senior writer for Slate. Glenn, Mark, thank you both very much for being here. Mark, you're here at the table, so I'm going to start with you. You were initially skeptical of the Manhattan District Attorney's case, but you've come around. What's changed your mind about the importance of this trial?
Well, over the past year, I think Manhattan District Attorney Alvin Bragg and his team have made an extraordinarily strong case case that this really was a felony offense under New York law, that it wasn't just a misdemeanor involving some kind of low-level record-keeping crime, but that it was tied in fundamentally to federal and state laws involving campaign finance and election interference. That's why District Attorney Bragg has made such an effort over and over again to say this is not just about a porn star or hush money. This is election interference. I think that's a really important point because, you know, we're all watching these cases about 2020 get stuck in the lower courts, not go to trial. This is the first to go forward. There's been a temptation among some cynics to say this one doesn't really matter. It's not a big deal. But the fact that it is fundamentally about honest elections and whether Trump can break all the rules that apply to everyone else, I think that matters, and it really raises the stakes here. I was sort of convinced that this was the right time to bring these charges and that they were the right charges because the district attorney has showed that if Trump is found guilty of these offenses, that he truly did conspire to violate state and federal election laws. That is a serious offense, and he should be held accountable.
All right, Glenn, you are the former federal prosecutor here. Were you also initially skeptical of this case, the Manhattan District Attorney's case?
I was really not all that skeptical, Jonathan. When you see the mountain of evidence, okay, this is coming from a former career prosecutor, I understand, but when you see the mountain of evidence that has been amassed against Donald Trump, you know, when the folks who are suspicious of the sort of quality of the evidence in this case go to things like, well, Michael Cohen was lying. Okay, of course Michael Cohen was lying. In fact, in large part to try to protect Donald Trump and keep him out of hot water. But, you know, it's not the question of whether a witness lied previously that will convince a jury about the strength or weakness of the case. It's whether that witness is telling the truth now and whether the witness is corroborated with things like covert audio recordings of Donald Trump and Michael Cohen conspiring to commit the crime. Check with hard evidence like documents and reimbursement checks that Donald Trump was writing, including out of the Oval Office. Check, you take the weakness of Michael Cohen lying and you turn it into a strength because you talk about his motive for lying, which was to help his former boss. So I am not all that concerned that if the jury follows the evidence and applies the instructions of law as Judge Merchan gives it to them, I am fairly confident they may end up convicting Donald Trump, and they may do it in a New York minute.
Mm-hmm. Hey, Glenn, jurors have already had to worry about their identities being leaked. A couple jurors have already been asked to be removed from the case. Might we see other jurors asked to be dismissed?
You know, I feel like it's almost inevitable that we're going to have other jury bumps along the way here. It's not that unusual, Jonathan. When we pick a jury, we send the jurors home for the night. They come back the next day to begin hearing opening statements. And one or more of the jurors are like, you know what, Judge, I came up with some reasons, some concerns, and I might not be able to sit. That happens all the time. And then, early on in the process, the judge, if those reasons are valid, can dismiss that juror and replace that juror with an alternate. I have a lingering concern, Jonathan, that because there are only 6 alternates seated, if we have an unusually high number of jurors who feel like they want to get off the jury, maybe, they're feeling uncomfortable, maybe they've been gotten to, I've had that happen over the years. I hope 6 is enough, and I trust 6 will be enough.
Mm-hmm. Hey, Mark, Maggie Haberman in the New York Times, and I'm quoting here, she writes, people close to Trump are anxious about how he will handle having so little to do as he sits there for weeks on end. It has been decades since he has had to spend so much time in the immediate vicinity of anyone who is not part of his family, his staff, or his throng of admirers. What kind of impression do you think Trump is making so far with the jury?
I think Trump has made a poor impression with potential jurors so far. Based on reports from inside the courtroom, we know that he has looked hostile, sometimes even aggressive, as jurors have paraded before him, saying their true feelings about the former president. This is Manhattan. Many of those feelings are far from positive. A lot of these potential jurors have criticized him, said things to his face that he probably has not heard in person for many years since he's so insulated from these criticisms. Jurors pick up on that. They pick up on body language. They pick up on muttering. They take it often as a sign of untrustworthiness, that the defendant might have something to hide. And it's not going to play well for him once this actually goes to trial this coming week.
Hey, Glenn, what do you expect at Trump's Supreme Court hearing on immunity this week?
So, Jonathan, I'm not so concerned that the Supreme Court is going to say a president can commit any and all crimes against the people of the United States in violation of the federal laws and do so with complete impunity and immunity from prosecution. I have a greater concern that they're going to be so interested in what they call outer perimeter immunity, which is not a thing in the criminal law, but it is a thing in the civil law. And, you know, they may conclude that, well, if there are some outer perimeter crimes the president commits, maybe he should have immunity for that. And the only way we will know whether any of what Donald Trump did should enjoy outer perimeter immunity is to send it back to Judge Chutkan to hold all kinds of evidentiary hearings on whether some of what he did might enjoy some outer perimeter protection. Then it can come back to the Supreme Court. Then we can definitively resolve the case. The reason I am concerned about that is it will eat up so much time. Donald Trump may not be tried until, who knows, 2026.
Well, Glenn, speaking of eating up time, I'm going to have you come back because this whole idea of outer perimeter immunity demands its own segment. It defies logic to this layman here. But Glenn Kirschner, Mark Joseph Stern, thank you both very much for coming.
You know, Nicole, the last thing anybody wants, anybody except perhaps Donald Trump, is for jurors to feel intimidated and let that creep in to their assessment of the case, let it creep in to their deliberations. You really want the jurors to decide the case only based on the facts and the law as the judge instructs them on the law. And, you know, Donald Trump seems intent on injecting fear and intimidation and threats, either himself or through his supporters, when he posts things about his perceived enemies and he names names. You know, we all know what he is signaling to his supporters. Basically, get him, get after them in any way you can. So I think it's going to be really important that this jury is protected not only against actual violence, but against intimidation, you know, from any source. And I think Judge Merchan is up to the task, but I also think he has his hands full. You know, I tried RICO cases in the courts of D.C. where we had anonymous juries. I only tried 2 of those in my 30 years as a prosecutor, both in the military and in the civilian sector. And it was because we were trying a case against the largest criminal organization that we ever charged under the RICO laws. The Washington Post dubbed the organization Murder Inc., Murder Incorporated, and that kind of stuck, at least through the course of the trial. And it was because that criminal organization killed 31 people over the course of about 8 or 9 years. They killed their perceived enemies. They killed witnesses against the organization. They actually killed their own members when the members tried to leave the organization, because if you left the organization, there was at least a risk that you might cooperate with the authorities and flip against the organization. So when I think about the fact that in my experience as a career prosecutor, there were only 2 trials that required anonymous juries, and those were the kinds of people we were prosecuting. And now we have a need for an anonymous jury when we're prosecuting a former president of the United States.
Let me ask you 2 things about that, Glenn. I mean, we also have a call and response pattern on the record when it comes to Donald Trump. To the Proud Boys, quote, stand back and stand by. To Mike Pence, who had run for his own safety and that of his family after that fact, a fact certainly known by Secret Service protecting both Donald Trump and Mike Pence. Trump tweets out another threat, endangering his life further. I mean, we know that there isn't a circuit breaker when it comes to an imminent threat of violence against someone who has displeased him. How do you protect a jury who doesn't have the kind of Secret Service protection Mike Pence had?
Well, I will say when our jurors were anonymous, and let me add, they were anonymous to us, the prosecutors and the defense attorneys. We didn't even know their names. So I sat there in court for 6 months staring at them, and they were staring at us. And I didn't even know their names. In fact, I remember getting up in closing arguments after 6 months and saying, folks, we've been staring at each other for 6 months. Do you know how happy I am that I finally get to talk directly with you? And but we had U.S. Marshals that would transport the jurors to the courthouse every day from an undisclosed location. We didn't know where they were picking them up. And at the end of every trial day, they would be transported back out by the U.S. Marshals to that undisclosed location. I hope that if that becomes necessary, they, implement similar security procedures and protocols in the New York case, because I have a feeling it's going to be a very bumpy ride for these jurors.
Let me just share with our viewers what we believe to be happening right now. Judge Juan Merchan, the judge overseeing the first ever criminal trial of an American ex-president, announced just about 21 minutes ago that the jury had been selected. He then swore in 12 jurors who will, along with the alternates, one of whom has been selected, 5 additional at least, will be selected tomorrow. Donald Trump appeared to come out and wave around some papers. We chose not to listen to that, but we'll make sure that if you missed anything important, we'll be able to report that for you. We are waiting for our correspondents who are still inside the courthouse locked down. And you said this has been the practice all day.
Right, they're locked down because, first of all, they've got to get the jurors out so that the media and the jurors don't run into each other. Often there's the case you can get into an elevator and have jurors in the elevator, and I've been in a situation like that where we've been called in front of a judge after that has happened. Also, Donald Trump has to get out of the building, and he has Secret Service. But the most important thing is those jurors get out and they have no interaction with anybody involved in the case. So it can take time. Today I was coming up to the show. I hope to kind of try to get out of there with a little bit of time on the subway, and I was locked in the courtroom until 3:20, 3:25, and had to run up here. They were not letting anybody out because there was jurors in the hallway. They were moving them from one room to the other. So it's a complicated dance up on that 15th floor right outside the courtroom.
And tomorrow there'll be another influx, right?
There will, and I noticed today that they're being really a lot more careful, I think, even than they were. The lockdowns are longer, and they're often locked down. And like, I was surprised at 3 p.m. It's not like a lunch hour that they were locking them down. They're just trying to do everything they can to make sure that they're coming in and out without interaction.
There's an irony there, right, in that there's this extra security because of the Secret Service protecting the former president. But in terms of who actually needs protection in this situation, it seems that it's actually the jurors as much, if not more, than here. Right. So the situation is bizarre.
It's kind of, and the other thing is you go through security when you come into the building in the morning. Everybody goes through this. And then when you get to the 15th floor, there is a whole nother level of security that involves the Secret Service, and you've got the mags out. So you have to go through that twice. It takes a long time. And I don't know if we're ever going to figure out how much money is being spent on this between the court police, the state police, the city police, and I don't even know who else. We'll probably never figure that out, but it is just enormous.
And the Secret Service?
And the Secret Service. Right. Simply to have a form of justice downtown for Donald Trump.
You know, one of the failures in our politics was this failure of imagination, right? People couldn't imagine someone running against first Hillary Clinton and then Joe Biden in the way that Trump did, so crass and so craven, and then politically surviving things like the release of the Access Hollywood tape. I wonder if there are any parallels to be drawn with the rule of law. Are there any things that people haven't imagined in terms of the kind of ways that we protect jurors?
Well, I was going to say, what we're encountering right now is Donald Trump against the criminal justice system.
Right. Just
as we saw him encountering the civil legal justice system with E.G. and Carroll in the civil fraud case. And so lawyers and courts and court staff, I think, are not accustomed to having to deal with somebody who will not abide by the norms.
Or a gag order.
Or a gag order. And, with respect to the jurors and what we're seeing happening in real time in terms of the threats to them and the concerns they have about their safety and their privacy, the judge anticipated that. When he amended the last gag order against Donald Trump, he extended it to family members of himself and the others involved in the case, precisely because he said, I'm not only concerned about the safety of my family and the families of the other lawyers, et cetera, but I'm concerned about essentially the ripple effects that jurors, potential jurors and witnesses will be worried about participating in this case in any way, shape, or form because of concerns about their own safety and those of their families. So he saw that this was coming, and there's a lot riding on whether he enforces that gag order when there's a hearing on it next week, because he's going to be setting the tone for what happens henceforth.
What should he do?
Well, the DA has asked for fines. I think the last time I read their filing, it was $1,000 per violation, but that was at the time that there were 3 alleged violations. I think now we're up to at least 10, and it seems like they're happening more by the hour. And so it'll be very interesting to see if they ask for something other than monetary fines. That gets really tricky if they're going to ask for him to be held in custody. I imagine they're going to just ask for more in the nature of fines and a stern admonition and taking down social media posts. But if the judge does that and then Trump continues to violate the order, then again, we're in uncharted territory, and the judge really has his work cut out for him in terms of maintaining order here.
Trump doesn't care about fines. You know, $10,000.
He just lost $500 million. I mean, he borrowed it from some guy in LA. I mean, you know.
Yeah, it's just not going to, you know, the fact is that because he wages, you know, this daily assault on rules, and then we're surprised because normal, healthy people aren't unhinged enough to violate every sort of civic norm in the way that he does. It empowers him to keep doing it. And unless there's just a hard penalty on the other side of rule breaking, then the rules don't matter. And I think that it will not be fines. He won't even pay for the fine himself, whatever the amount is. Right. And it could be $100,000 or $500,000. I don't think he cares, because I think he believes that he's getting a lot of value out of assaulting civic norms and the rule of law in the way he does. And it's worth $10,000 to $500,000 to him. I don't think he'll want to sit in a cell.
The one thing that if he disrupts the proceedings and it's viewed by the judge, he's been told he's going to jail, and I think that's the line that's going to be really interesting to watch.
He's tweeted about it. He said, I look forward, it would be my honor to go to jail. We'll see. I don't know.
There's nothing, he's a martyr, so.
Correct. Glenn Kirschner, I want to read to you some brand new reporting we just got in from the pool. Before court ended for the day, Trump's attorney, Todd Blanche, asked if they could find out the names of the first 3 witnesses. Steinglass, that's the prosecutor, replied that it's a courtesy they normally extend, but he refused to in this case. He said, quote, Mr. Trump has been tweeting about the witnesses. We're not telling them who the witnesses are. Judge Merchan said, quote, he can't blame them. Blanche seemed mystified. Sorry, I didn't mean to laugh. And asked if he's not going to find out who the witnesses are until they walk in the door. He offered to, quote, commit to the court and the people that President Trump will not. The verb is truth. I think that's his social media thing. Truth about any witnesses. Merchan said, quote, I don't think you can make that representation. Blanche, Trump's lawyer, offered a different solution, giving the witness names to the lawyers. This is delicious. But they wouldn't share them with Trump. Quote, I'm not going to order them to do it. No, I'll see you tomorrow morning, said Merchan. What are we learning about Merchan, Glenn?
Yeah, well, first of all, when a defendant is so dangerous that we have to ask for what are called protective orders, not all that unusual, but usually reserved for some of our nation's most violent offenders, what we do is we will ask the judge to direct the defense counsel not to provide information to the client. That gets a little dicey, but we use protective orders not infrequently. It sounds like Judge Merchan is not even willing to do that. And what I say is safety first. The system needs to rise up and protect these witnesses. So as a courtesy, I absolutely agree. I would almost always give the defense notice of the order of call. That is, who are the witnesses who we are expected to put on the stand tomorrow and the next day and the next day. It's the courteous thing to do, but safety first. So, and we continue for whatever reason, Nicole, we're all talking about how fines won't mean anything to him. But, the law actually has a vehicle to hold a dangerous pretrial defendant accountable, and it's called pretrial detention. If there's clear and convincing evidence that the defendant who's on release in a felony case presents a danger to the community or even one person in the community, the law says he can be detained pending trial for whatever reason. And this is the one thing that shakes me to my core and causes me to lose a little bit of faith in the institutions of government. For whatever reason, the institutions of government have decided we will sacrifice the safety of everybody else to leave Donald Trump out and about to endanger his perceived enemies. And that's witnesses and jurors and prosecutors and judges and their family members, when the law actually has a way to take care of a defendant on pretrial release who presents a danger to all of those people. And yet no institution, no prosecutor, no judge has opted to sort of prod that part of the law into wakefulness.
Do you think that's going to change, Glenn? I mean, do you think there's a tripwire here? Is there conduct that could change? I mean, I share your assessment. I think you know that. But do you think there's conduct that could change that?
I do. And here's what happens when defendants violate orders, and they continue to violate orders. Judges take it incrementally. The first violation is usually a stern warning. The second violation is fines. But when the fines come, the judges will generally say, and I promise you, Mr. Defendant, if you do it again for a third time, you're going into a jail cell. I have a hard time imagining Donald Trump making it through this trial without landing in a jail cell.
Wow. So we both said well. I caught that too, and we both said well.
I'd like to know just from Glenn, do you think the judge is just sort of storing these up? Like, I'd like to have a hearing now.
Well, there's 7, right? I mean, did they get to 10?
They added 7 today to an existing list.
Right.
So there's more than 7.
So we're at almost Baker's dozen of violations of the gag order. Glenn, is it a matter of time before you have a hearing on the gag order, or do you think he's sort of waiting for these to stack up like planes at LaGuardia?
Yeah, so people wanted to know, why is he going to wait a week to first take up the contempt motion? And I think it's because under New York state law, there are different kinds of contempt. If the contempt is committed in the presence of the judge, that's when, just like in the movies, the judge can bang the gavel and summarily say, I hold you in contempt. But if the contempt is not committed in the presence of the judge, then the New York state law provides the defendant is entitled to notice and an opportunity to defend. And I think that is why Judge Merchan set them off for about a week. But they're going to pile up, and I think Donald Trump is going to continue to behave badly, and then Judge Merchan is going to have a decision to make. And do I do what I would do to any other litigant in these circumstances and put him in a jail cell?